So what I'm going to talk about now is where have Lassiter and Turner left us? And here's the good news, because there is some good news in this. State courts are not obligated to follow Lassiter or Turner if they're interpreting their own state constitution. The only problem for that is you're in DC, and DC doesn't have a constitution, so you're kind of out of luck on that one. I'm sorry. But move to other jurisdictions and you can do some stuff. So anyway, the many state courts have said, we don't agree with this jurisprudence, we're going to find a right to counsel under our state constitution, even if the state constitution's due process clause is worded exactly the same as the federal one. That does not mean the court has to interpret it the same way. It is under no obligation. When it's interpreting the state due process clause or the state equal protection clause, it can do whatever it wants. They often are influenced by the Supreme Court, but they're not required to follow it. So that's very important. So where has Lassiter and Turner, where have Lassiter and Turner and the state courts left us at this point? This is where we are. And then I'll get to where we're going, what we're trying to do to change it. So before I show you these, just remember, this is the only time you're going to be tested in my presentation, but there were 5 basic human needs areas: shelter, safety, sustenance, health, child custody. After I'm done showing you what exists, we're going to talk about what's missing of those 5. So here's what we've got. Termination of parental rights, abuse, neglect. By statute or by constitution, most jurisdictions. Termination is 44 states, so almost every state, and DC. Abuse, neglect, I think is 38 states, if I recall correctly. 11 states that found a right to counsel in termination under the federal constitution went back after Lassiter and said, we don't agree with Lassiter, we're going to find it under our state constitution also. So really a strong rejection of Lassiter when it came to termination of parental rights. Civil contempt. This one's got an asterisk because it was a majority of states until Turner came along. Turner upset the apple cart because all those state courts that relied on the federal constitution are now going to have to go back and reevaluate, and we don't know what they're going to say now that there hasn't been enough time yet to see what they're going to say. But before Turner, it was a majority either by statute or by constitution. Involuntary commitment for mental health. Not too hard to understand. You're going to a facility, your physical liberty is going to be restricted. Quarantine, same thing, physical liberty. The thing that you'll see, the trend you're going to see is that either parental rights or physical liberty are the 2 things that the courts have been most easily able to identify rights to counsel for. Judicial bypass is in states that require minors to obtain parental consent for an abortion. The Supreme Court said if you're going to require parental consent, you have to allow a process for a judge to waive that requirement. And the states that have that requirement have generally provided counsel, which is good. Although I will tell you a sad anecdote that in my home state of Alabama, some judges have seen fit to appoint counsel for the fetus instead of the minor, turning what is supposed to be a completely neutral process between the minor and the judge into an adversarial process between the guardian and the minor, which is just wrong on so many levels, and again, another day. Guardianship, again, sort of physical liberty, you're very constrained under guardianship, so a lot of states have recognized counsel in that. Then we get to, these are the states where a lot, but not a majority, have found a right to counsel. Adult protective proceedings, adults who are in danger of harming themselves, again, physical liberty kind of connotations to it. Paternity has that family connotation, you're having a parental relationship established, maybe one that you don't want. Non-consensual adoption, this area is the hot button right now, because this is something that most people, I tell people this, and they say, that can't happen. It can happen. I can walk in a lot of states, I can walk into someone's house and say, I want to adopt your kids against your will. And there's a process whereby this happens. It's called non-consensual or contested adoption. It's just like termination of parental rights, except instead of the state doing it, it's just a private party. The difference is when the state tries to terminate parental rights, there are all these protections that go around it, including the state has to try to reunify the parents first. It has to try a whole lot of things before it gives up and tries to terminate parental rights. With adoption, bam, just like that. The whole thing starts and ends with one proceeding. Your kids can be taken away based on allegations that are much less reviewed and processed in an adoption proceeding than they would have been if the state had done it. 5 state courts have said a state cannot provide counsel in a state-initiated proceeding and not provide it in the adoption context. That's a violation of equal protection, because the parents in both situations are in the same position, with the only difference being who the plaintiff is. So I will also tell you another really scary anecdote, that we saw a case where the state was prosecuting a termination and it wasn't going to win because counsel for the parent was fighting and succeeding. So the state dropped its termination petition, and on the same day, the adoptive parents that the state had been working with filed a petition for adoption. The parents' counsel, gone, because under the statute for adoption, he didn't have a right to counsel. And even the state Supreme Court said, it's obvious what happened here. This was clearly a maneuver to deprive the birth parent of counsel. That was the only reason why the state dropped its petition. And that's obviously a very serious concern when people are playing these games to try to deprive people of a lawyer. Sexually dangerous persons, sexually violent persons, another area that's emerging area of law. These are situations where states seek to keep people in prison after their sentence is over on the theory that they're dangerous. But it's civil, so therefore they don't have a right to counsel under Gideon, even though they could spend another 10 years in prison. So very complicated new area of law. Some courts are saying, if you're going to do this, you've got to provide counsel. Parole revocation, I'm not going to get into that. So now we get to the ones where one state or maybe 2 have a right to counsel. Do you remember those 5 areas? What those were? What were they? Shelter,
Safety,
sustenance,
health, and child.
Health and child custody. Okay. So custody, we've got 1.5 states. Domestic violence, which is safety, no state. Actually, sorry, 1 state, New York, and then 2 decisions from Ohio, one from Ohio, one from Jersey, that provide it in part for juveniles. Public benefits, no state, except for a couple of very minor ones that I don't have time to get into. Special immigrant juvenile status, this is for minors in Florida. And then you start to get into ones where you start wondering why the state prioritized this over, for instance, termination of parental rights. When you start getting into compliance with livestock disease prevention, while this is no doubt a serious matter for a person who has livestock, when it comes to choosing that or parental rights, and then my favorite one, out-of-state owners of cars seized for illegal explosives. Apparently is a civil proceeding, and they have counsel for that, but not for other things. So the word patchwork is an understatement by a long shot. So like we just said, we've got a lot of things missing. So basically what I'm going to tell you in 8 minutes or less is what we're trying to do to fix it. The most amount of work is being done legislatively and litigation-wise for family law. These cases, these are all statutes that have been passed or attempted in the last 5 to 6 years. So abuse, neglect for children and adults, contested adoptions. Louisiana is a really bizarre situation because Louisiana passed a right to counsel unanimously for parents in contested adoptions in 2009, and then 2011 repealed the same statute unanimously. What on earth is going on there? It's like there's just some really crazy stuff going on. The state of New Hampshire repealed its right to counsel for abuse and neglect cases, and now is considering restoring it 2 years later. I mean, it's like there's very strange stuff going on in some of this stuff. Some attempts to expand some of these other areas by statute. You can see a little bit on immigration and guardianship, juvenile right to counsel. Again, I don't have time to get into all of this, but the message here is to look at the list of states and see, a lot of people think the right to counsel movement is happening in New York and California. But if you look at the list on here, we've got Texas, we've got Ohio, Pennsylvania, Tennessee, North Carolina. This is all over the country that people are attempting to do this. There's a lot going on. Litigation, there's also a ton. Don't have time to go into all of it, except again, look at the list of states. For family law cases, we've got New Hampshire, Montana, Ohio, Texas, Arkansas, Washington, New Jersey. This is happening all over the country. Litigation is increasing as people are seeing this as the only way to go because the legislatures are hopelessly stalled on money issues. A couple of other interesting ones that are happening or have happened, truancy, contempt, protective orders. The protective order ones are the most exciting because the decisions from Jersey and Ohio are the first ever decisions to find a right to counsel in a domestic violence context. Before that, all we'd seen is bad case law. So some courts starting to recognize that DV is a serious issue that they need to address. And guardianship. The pilot projects are going to be talked about later, especially by Claire, so I'm not going to spend a lot of time talking about them, except to say that these also are the future, because if we want to convince the legislature that these programs to provide counsel are less expensive, we need the data to prove it. And we need the data to prove that the impact of providing counsel is significant. Claire will talk about California. Massachusetts did a great set of eviction pilots that found that counsel made a big difference. And there are currently some pilots going on in Iowa and New York on immigration and domestic violence. I'm not going to talk about the bar associations except to say they've been great on studying the issue. They've written articles like this one and other stuff too. The Access to Justice Commission's also really terrific. And I'll just highlight Maryland in specific, that it actually put a dollar figure on the cost of providing counsel across the state in Maryland. Does anyone want to guess how much it said it would cost? Just throw out a number.
100 million.
Who said 100 million? That's like bam on the knob. That was almost exactly what it said, actually.
That's why she's the name.
There you go. I wish I had some candy to throw or something. Yes, it basically said that providing the right to counsel statewide, as it defined the right to counsel, would cost about $100 million, which sounds like a lot, I will not lie. But it also costs a lot to pay for prisons, and pay for foster care, and pay for all the other things that the state pays for because it doesn't provide counsel. There have been also, besides litigation and legislation, there have been efforts to establish documents that lay out systems for providing counsel, model acts, petitions to courts to change their rules to provide for appointment of counsel. And in New York especially, the chief judge in New York, Judge Littman, has basically said, I believe in a right to counsel. That's my goal in the state of New York. He's already said he plans to provide counsel for everyone in foreclosure. This is actually an article talking about Judge Littman's efforts. And we've seen a few chief justices do this. In California, the chief justice without him, the pilots would never have happened. That 11 million, 10 million a year that they got would never have happened. So that is everything you wanted to know, but not really in 30 minutes about counsel.